Great, let's get started. We have an announcement first.
Hi, I am the marketing officer of Women in Computing, and I just wanted to invite you all to an event. So this Thursday, the Vice President of Engineering at Mainframes, she's coming to give a talk on blockchaining and decentralized development, which is really important these days. So it's going to be at 4:30 this Thursday, and it's, let me look up the number really quick, but it's MEB 3147. So it's right next to the School of Computing offices. It's just like this conference room right next to it. So there will be refreshments, 4:30 this Thursday. Hope to see all of you there. Thanks.
Okay. So PS12 is out, and PS11 is due today with a late day. PS12 is due Monday, Tuesday with a late day. Any questions or problems about anything? Okay, there's something I mentioned before, but I think it bears mentioning again. So when you run the grading tests against, or any, so when you run my grading test against your PS11 or your PS10 for that matter, you need to have your service, you need to start it up in one Visual Studio and run the unit test in another instance of Visual Studio. Then when you fail a test and you want to debug, you got to realize that if you start single-stepping your test case over here in this Visual Studio, it's not going to magically, when you make this call to the server, it's not going to start single-stepping over in the server. It's two separate Visual Studios. So what you'll have to do to debug is you'll have to run your server over here, set a breakpoint in the method you want, at the endpoint you're trying to debug over here. And then over here, when the test case calls the service, you'll hit the breakpoint over yonder in this Visual Studio. Then you can step through and see what's going on. One thing that frustrates students in their debugging is if your service throws an unhandled exception, you're used to that killing your program, and you get a stack trace in the output window, and you can figure out what went on. But it won't work that way with the service. If your service throws an unhandled exception, the server, the IIS server, notices the exception was thrown and turns it into like a 501 internal server error that goes back to your test cases. And the stack trace is nowhere to be seen. So to see these stack traces, you need to do something. And the simplest thing to do is just to put try-catch around each of your endpoint methods, as well as if you have like a constructor, put it around that as well. And then have a try that catches the exception and prints out the stack trace for you, and then rethrows the exception. Something like that. Otherwise, you're just not going to see those exceptions. And it's hard to debug when, I was helping people yesterday, and they're getting this 501 error, and it turned out it was just a run-of-the-mill mistake in the server, but it was in the service code, but it's completely, it's impossible to find without any kind of indication of where it was, what line it was on. Once we could see the stack trace, it was easy. So do keep that in mind. Okay? All right, today we're going to talk about something kind of different than what we've been talking about. We'll talk about intellectual property. So intellectual property means product of the mind. And when we talk about intellectual property, we're talking about trademarks, trade secrets, copyrights, and patents. The protection of intellectual property is enshrined in the Constitution of the United States. So, it's not, if you think the government overreaches and makes laws that they have no business making, copyright and patent is right there in the Constitution. So it says the Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So it says a couple things. It says Congress has the power to do this, but it also gives the reason, and the reason Congress has the power to do this. So what is the reason behind intellectual property protections? What's the reason behind copyrights and patents? Yeah.
To, I guess, promote the progress of science.
Right, to promote the progress of science and useful arts. So, and then it also says, by securing for limited times the exclusive right. So let's put that together. How does, essentially what a patent does is it gives to the inventor the exclusive right to benefit from that invention for a limited time, which is nowadays 20 years. And after the 20 years are over, anyone can use the idea from the patent. So how does this promote the progress of science? Yeah?
Yeah, it's basically just like an incentive to make money while you have exclusive access to this patent, while simultaneously making that patent public so that other people can then use your discovery after that 20 years is up.
Okay. So as he said, he put it perfectly. To get a patent, you have to explain your invention, and it becomes public record. So you can go find any patent you want on the internet. So it's an incentive for the inventors to make their inventions known, to explain the ideas behind their inventions. They get to benefit from it for 20 years, but then it's in the public domain. Anyone can use it, and so it helps. If everyone kept their ideas secret, no one talked to each other, it would make it harder to make progress. And the same thing goes with copyright. There are different kinds of things, but you write a book, you benefit from it for a long time, but eventually it enters the public domain. Remember that limited time thing, because we'll run up against that in a few minutes. So what does this have to do with software engineering? Why are we talking about intellectual property here? Yeah?
Depending on who you work for, things like that, what you make might not be generally it's like working at the school. If you do research, that's not yours, it's the school owns it, so you don't have the power over it. Or if you work for a company, you can't.
Okay.
Like in the trade secrets.
All right, so one thing, I'll summarize what he said. Depending on what arrangement you have with your employer, what you create may not belong to you. So for example, if I were to make an amazing discovery as an employee of the U, and if I made the discovery sort of as part of my job, they've got an interest in that, and we sort of share any money that the idea derives. On the other hand, if you as students make an amazing discovery, if you're just in a class, the U doesn't have any say in that. It's your invention, but you sort of need to know what when you're doing something. Are you working for yourself? Are you working for someone else? Yeah.
Do you know if that license we get for Visual Studio, that's from the school, right? That we get?
No, the license is from Microsoft.
Okay.
Yeah. Yeah, you wonder what's in the fine print that you never read.
Yes. I don't know what I would read.
Was there another idea out there why this belongs in software engineering?
Yeah, all this skeleton code you've given us all semester says that you will write to it.
Okay. Right, so I started doing that because in 1410 last semester, I kept finding my solutions and my assignments all over the internet, and on cheating websites. And if I ever want to get energetic enough to ask these sites to take down my code, I wanted to make it clear that that I was the one that owned it. Okay. What about software engineering can be patented or copyrighted? Do you know? Can programs be copyrighted? Can programs be patented?
It depends on how specific that patent is.
Yeah, he said it depends on how specific the patent is. But it turns out that any program that you write, anything that you write, you have the copyright on. You don't have to put copyright your name on it. You don't have to register it with the government. If you write it, you own the copyright. Okay, unless you've signed away your rights to an employer or something. And there are aspects of programs you can't patent a program. You can patent ideas, novel ideas that go into creating a program. You can certainly violate patents and violate copyrights. So if you're an employee of a company and you go copy code from some other source without their permission and put it into your code that your company is using, you've violated a copyright. your company has violated copyright. So it's not just a matter of we're worried about people cheating in a class. If the analogous thing in a job, cheating in a job, is violating a copyright, and that could get you and your company into serious trouble. So you need to know what copyright and patent means. So we'll start with a simple one, trademark. So USTPO is the United States Trademark and Patent Office. And I took some of these definitions off their website. A trademark is a word, phrase, symbol, and or design that identifies and distinguishes the source of the goods of one party from those of others. So you're probably familiar with trademarks, and you'll see a little T with a circle in it next to different things, and that just says that it's, I'm trying to see if this blue here is trademarked. That means it's registered with the United States, with the USTPO. So if you are Coca-Cola, or say you're McDonald's, and you want to trademark that name McDonald's so that you trademark it so that other companies can't go into business and call themselves McDonald's. So you sort of have the sole control over that McDonald's. You go to the USTPO and you register the trademark with them, and you pay some money, and you have to renew it ever so often. And then you sort of have the exclusive use of that name. So it's used for branding. So all kinds of things can be trademarked. McDonald's can be trademarked. This slogan by Capital One, "What's in your wallet?" that's trademarked. So another credit card company couldn't start making ads that use that catchphrase. The shape of a Coke bottle is trademarked. You know, a Coke bottle is sort of an hourglass shape, and a Pepsi bottle is more of a straight contour. And if Pepsi started making their bottles to resemble Coke's bottles, Coke wouldn't have it. They trademarked that shape. The Jolly Green Giant, where he goes ho ho ho, the descending three notes, that's trademarked. That sound is trademarked. The color brown is trademarked by UPS for use on trucks and uniforms. So it's amazing the kinds of things you can trademark.
Isn't the Christmas song like copyrighted or something?
The Happy Birthday was copyrighted, but I believe it finally came out from under copyright.
I think some lady just did it because it wasn't.
Yeah, it was. Yeah, that has a long story, and it used to be when I was a kid. There was sort of one Happy Birthday song, and that was it. But then it got to where you go to a restaurant, and when they want to sing Happy Birthday, they had to sing their own song because someone was trying to enforce the copyright on the traditional Happy Birthday song. Well, anyway, trade secret is another way to protect intellectual property. So the USTPO says that's information used in business that gives an opportunity to obtain an economic advantage over competitors. So it's essentially something that some company knows, and they don't want to share it with the world. Maybe they don't want to patent it because they want to benefit from it for more than 20 years. Or maybe they don't want to patent it because they figure if they don't patent it, no one else can figure out how they do it. And so what they do is they just keep it a secret. So examples of that's the recipe for Coca-Cola. If it had been patented, they've been making Coke since the 19th century. It had been patented, if their formula had been patented in the 19th century, it would have been in public domain for over 100 years now. But instead, they keep it in a bank vault in Atlanta or whatever, and keep it a secret, a trade secret. So if someone, so you don't register a trade secret, it's not like a trademark. You don't publish it. It's just sort of treated like property, so that if someone broke into the bank vault and stole your trade secret, the courts can intervene. Or if some employee, without authorization, gives away a trade secret, you can sue the employee. But if you mess up, if you release the trade secret by accident, you're just out of luck. It's on you to keep it secret. Or if someone else figures it out, if someone else reverse engineers the recipe for Coke and starts making a new soft drink that tastes just the same, they can't put it in an iconic Coke bottle, but they can use that recipe because they figured it out. Now, on the other hand, if it was patented for 20 years, people couldn't do that. The formula for WD-40 is a secret, and Kentucky Fried Chicken's blend of 11 herbs and spices is another example of a trade secret.
I have a quick question on
Yeah.
the trade secret.
Mm-hmm.
What happens if, you've had a trade secret for 100 years,
Mhm.
then somebody tries to, or somebody else discovers that trade secret and then tries to patent that, can you even apply for a patent at that point? Or, because it, basically they can take
Yeah.
potentially take it for 20 years.
Yeah, we'll talk about patents later, but when you apply for a patent, the patent office searches what's called the prior art. They try to figure out if it's already existed. Did you really invent it? In this case, you can't claim you invented Coke, so they wouldn't be able to patent it. All right, copyright provides protection for original works of authorship fixed in a tangible medium of expression. So these are kinds of things you can copyright. Musical works, sound recordings, literary works, and for a number of years, computer programs weren't considered copyrightable, but nowadays they are. They're treated as literary works. Dramatic works, movies, choreography, sculpture, architecture. So the design of a building is copyrightable. And the idea is copyright, well, let me just go to the next slide. If you hold the copyright on something, then you have the exclusive right to make copies of the work. Right? So if you write a Harry Potter novel, you're the only one that has the right to make copies and sell them. To produce derivative works. Although there are exceptions for parodies, for example. So this isn't as cut and dry as it might seem. To distribute copies, to perform the work in public. So if it's a play, if you don't, if you hold the copyright, you can tell other people they can't perform it. To display the work in public. The thing to realize about copyright is it protects expression, not ideas. So patent is for protecting inventions, novel ideas. Copyright is just for protecting expression, songs, movies, whatever. And there are lots of categories. Not all of these rights apply to every category. There are lots of special exceptions. But, and there's a very long history of copyrights and ways in which, it may or may not have been abused that we can talk about. So, the duration of copyright is one of those things that has a long history. So in 1978, the duration of works of copyright was changed, and then it was changed again in 1998. But nowadays, what it stands for is, if you write something, if you hold a copyright, it lasts until 70 years after you die, if you're the last surviving author. Okay, which seems, remember the Constitution says it secures exclusive rights for a limited time. So, 70 years after you die is a pretty long time if you're the author. If the author is unknown, or if the work was produced for hire for a company, then it lasts for either 95 years after it's first published, or 120 years from when it was first created. So it could have been created and then eventually published. So whichever of those is shorter. So copyrights last a very long time. The most recent extension, so it wasn't originally that long in 1978. It was even shorter before 1978. It was made in 1998, and the critics called it the Mickey Mouse Protection Act, because Mickey Mouse, the original Mickey Mouse movie, Steamboat Willie, was about to come out of copyright, and so they extended duration. And I think now it's scheduled to come out of under copyright in 2023. There was a whole batch of stuff that came into the public domain in 2019, like when the year started. I remember that being in the news. Jack Valenti of the motion picture AA, I'm not sure what the AA stands for. All the content companies, the movie studios, they wanted copyrights to last forever, but the Constitution said they had to be limited. So his suggestion was that the duration of copyright should be forever minus 1 day to make it limited in duration, but that didn't fly with Congress. There are exceptions to the copyright law that are governed by what's called the fair use doctrine. And the idea is, if, let's say there's some copyrighted material and you want to use it without permission, you want to do something without permission. Maybe you want to make copies and hand it out to a class. So these are the guidelines a court would use to decide whether you were making fair use of copyrighted material. So first of all, the first thing the court would want to know is, why did you do it? If it's done for educational purposes, that's good from the standpoint of arguing it's fair use. So the law looks on educational usages as being more lenient. Commercial use, the court would frown on. The nature of the work. If it's factual, a book of recipes or an algorithms textbook, that's good. If it's creative, meaning a Star Wars movie, that's frowned on. The amount of work. If you copy just a little bit, the court will like that. If you copy a whole bunch, the court won't like that. So it's just a spectrum here. And then, what effect does the copy have on the value of the work? Did it cost anyone any money when you made the copy? So if it just cost them a little bit or nothing, that's look good for you. If it cost a lot, that's bad news for you in court. So what we're looking for is educational use of factual material where a small amount was copied and it didn't have much effect on anyone's bottom line. So what would sort of be an extreme example of a fair use of something where it's really tilted in these four directions? Yeah?
Just doing your homework, like using it for your homework.
Okay, so he's saying making a copy of something in order to do your homework?
Yeah.
Okay. Yeah?
Basically, I feel like the most obvious example is like news people, maybe just having like clips on CNN or something like that.
Okay. So like if there was some interesting thing I saw on CNN and I wanted to show during class.
Or CNN taking material from somewhere else and showing
Or CNN taking material to put it on the news. Example I would have is, suppose there was a page of a textbook I'd like to share with all of you. And the textbook is out of print. Okay, and the textbook is on software engineering. So I copy a page and put it on a slide and show to you. So technically I violated copyright. Right? I've made a copy, an unauthorized copy, and I'm sharing it in public. But I could argue, okay, it's for educational use. It's of a factual algorithms or software engineering textbook. I didn't copy but a single page out of 400 pages, and the thing's out of print. No one's making money on it anyway. So that would certainly stand muster, and I'm not violating copyright because I'm under this fair use exemption. I remember there was a company once that was in business to help professors what they claimed was they were helping professors make fair use of material. So what you could do is decide, okay, I don't want to have a textbook, but I want to take a chapter from this book and a chapter from that book and a chapter from that book and copy them all and staple them together and then give them to students, or actually students pay for them for the cost of copying. And they claimed that they were getting permission from the original copyright holders to do that, but it turned out they weren't, and they went out of business. I think they were sued out of business. So. It's a real thing. So this is a famous copyright lawsuit. Sony versus Universal in 1984. So Sony made the first VCR, video cassette recorder, and Universal is a movie studio. So Universal sued Sony because people were buying Sony's product, the VCR, and recording, movies and television shows off of television to watch later. And Sony's argument was that its users were making fair use of the copyrighted movies that were being copied. And you can see that it's kind of iffy if this really falls under fair use. It was clearly non-commercial, so they weren't arguing. Sony wasn't arguing that people should have the right to tape something off of the TV and then charge admission to see it. But they said it's just being taped for personal use, so it's certainly non-commercial, but it's not educational. But the movies weren't factual works necessarily; they were just entertainment. So that box isn't ticked. Users were taping the entire movies, not just one scene. But on the other hand, Universal couldn't show that it was costing them anything on their bottom line. So this went all the way to Supreme Court. So basically, the Supreme Court decided 5-4 that videotaping off of the TV was legal. This happened in 1984. So what would the world be like if the Supreme Court had gone the other way and said that VCRs constituted a copyright violation? Every time you use it, you're violating copyright.
VCRs only be bought or sold.
Well, he said VCRs wouldn't have been bought and sold, you know, and nowadays it's DVRs. But I think something different would have happened. Yeah?
I think this could have really have impact today's times where like you have like free music you can just download and movies you can download and like how YouTube just like shows videos of pretty much everything.
Yeah. I mean, you could imagine the same arguments being made against YouTube. You know, people are recording things and posting it on YouTube. That's actually a lot more damaging to a copyright holder than just a personal copy. But I think in 1984, if the Supreme Court had gone the other way, what would have happened is, if Congress didn't change the law, they would have put like a tax on blank VCR cassettes. And the proceeds from that tax would go to the content producers, something like that. But anyway, that's not what happened, and so taping was declared to be legal. It changed to some extent 20 years later, 15 years later with the DMCA. We'll talk about that in a second. Okay, here's another one, Sega versus Accolade. It's a video game thing. So Accolade was reverse engineering Sega games in order to create new games that would run on Sega's hardware. So they had to figure out how the hardware worked, so they could write code that would run on it. And they were doing it by looking at the existing games that Sega was making and reverse engineering it. And so Sega sued for a copyright violation because I guess they claimed that, I'm not sure where the copying, I guess they were making copies of the software in order to reverse engineer it. But Sega lost. There's a similar thing with Atari versus Nintendo, and another one with Connectix versus Sony. And in all those cases, the court said it was okay to, they weren't copying the games, they weren't selling games as their own. They were just figuring out how they worked and creating their own games. Yeah.
Nintendo did something funny, which is they added stickers that says the Nintendo approved to their own games because they wanted to keep the family image, but everyone was making games that were very not family friendly, things like that. So they added all this like Nintendo like approved games.
Well, there was also another reason behind the Nintendo approved sticker. Long story short, when the Atari 64 basically when the video game market on the Atari 64 crashed, basically, Nintendo tried to learn from their experience, and what they decided was happening was basically anyone could make a game for the Atari 64, so a lot of like really bad games were being made, like the infamous ET game, and there was no like quality control of games that could be made on the Atari 64. So what Nintendo did was, in addition to what is now standard practice of like keying games for your consoles, so you can't just run any disc on a Wii. They also added the Nintendo approved sticker as like quality assurance.
Okay, got something.
Close to the patents. The story behind the Sega against Nintendo, what Sega did, they approached the Office of Patents at the United States, and they just gave them the plans to all their patents and all their software, because apparently Sega needed it for I think it was a court case, but it was like a sham lawsuit. But while they were suing Nintendo, they started looking at all of their programs.
Oh.
Now it's illegal to get patents, so you need like a subpoena or at least some court, like a judge order to get a patent.
Well, not a patent. Patent's public domain.
No, like to get someone else's patent, to look at the paperwork.
No, the paperwork, I guess it depends what paperwork you're talking about, but the patent itself is public domain. Okay, now while I'm thinking about it, all this isn't related. The difference between a copyright and a patent is if someone, Margaret Mitchell wrote Gone with the Wind and held the copyright on it. If someone independently writes the same book and can prove that they didn't look at Gone with the Wind and they wrote the same book, or a chimpanzee typed it out at random, that's fine. So the copyright doesn't protect the story or whatever. It just protects a particular expression. It protects the book. And if someone else manages to invent the same thing independently, it's okay. With patents, it's different. Yeah.
Like there's like the hero's journey in a lot of like books. You can't patent that.
Right.
You can
Well,
copyright.
you can't copyright the hero's journey. Now, you could try to patent something like that, I suppose, but
Well, yeah, you can't copyright like the
yeah,
genre.
right. Yeah. Napster was, one of the first music sharing sites. And so in 2001, they had 50 million users with a bunch of MP3 files, or 2000, I guess. They were sued by the record industry. Napster claimed fair use, and they lost on every count. The bottom line was, they even claimed Sony versus Universal, that VCR lawsuit, as a precedent. But the bottom line was, with the VCR, there were lots of legal uses for it. Yeah, you could abuse it and use it illegally, to make illegal copies of something. But Napster had a hard time arguing that they basically their business model was copyright violation. And so they lost that. But of course, music sharing remained, just in different guise. This is an ongoing suit since 2010. So it's Oracle versus Google. So Oracle, Java was created by Sun Microsystems, and Oracle, I forget if they acquired Sun or bought Java, but anyway, Oracle controls Java today. And Google, as you probably know, uses Java for a lot of things. But they didn't want to pay Oracle. They didn't want to license Java from Oracle. So they created what's called a clean room implementation of Java and its libraries. So essentially, they took the language specification and they took the API descriptions and they just implemented all the code themselves. So it's completely compatible with Java, but it's one that they created without, looking at Oracle's code. So that's sort of the equivalent of the chimpanzee typing out Gone with the Wind. So Oracle sued Google for infringing its copyright on the API. So note, it's not, they weren't claiming they weren't saying that Google infringed the copyright on the source code, because Google claimed that they created it independently. It was on the actual API they were implementing. So the comments, basically, the design of the API, the names of the classes, the names of the methods, the specifications of the methods, all that was copied from Oracle into Google's clean room implementation. They provided new code. They didn't provide a whole new API. And that's gone back and forth. Typically what's happened is the juries have been finding for Google, and the judges have been vacating those findings and sort of overruling the juries. I'm not exactly sure how that works. Currently, Google's in the process of appealing to the Supreme Court. So that's that was in January that Google finally appealed to the Supreme Court, and Oracle's after $8.8 billion in damages for that. So that's so copyright issues come up all the time in software engineering. Now, digital media changed the whole playing field. So before the 90s, if you wanted to do large-scale copyright violations, so if you wanted to go into business to violate, to make illegal copies of movies and sell them on the black market, you had to have a large capital investment. You had to, have some. So for movies, you had some way of taking a movie and copying it, and then you had to produce reels of film, and you had to have some way to market it and distribute it physically around the country. But in the 90s, that all changed, because everything went digital. Like if you're in the business of copying books and selling copies of books, when you Xerox a book, the quality degrades, and if you Xerox it several times, it becomes unreadable. If you make a copy of a copy of a copy, but digital copies are always perfect, and it's really inexpensive to do it, and it's easy to ship bits around, and the data can be compressed to make it even cheaper. So it's the cost of committing copyright violation is no longer proportional to the harm you can cause by it. And so they revised the copyright laws right at the end of the millennium with the Digital Millennium Copyright Act. the main thing it addressed was, when is it okay to make digital copies of things? So let's take a break for a few minutes, since we've been going for a while, and I'll come back to this and tell you about the DMCA. Okay, so DMCA, it's the end of the 1900s, and actually Orrin Hatch, Senator Orrin Hatch, was the chair of the committee in the Senate that helped draft the DMCA. And one of our professors, who's retired now, Lee Holler, was on sabbatical and on Hatch's staff, and had a hand in this as well. So think about what an internet service provider does. And this applies to something like YouTube as well, or to Google. Just to play a recording, a digital recording of something internally, inside the hardware, the bits are being copied. So if you wanted to be really technical about it, just the act of playing something, the bits get copied off of the CD or whatever into memory and played. And the DMCA made it clear that was legal. So if you're an ISP and copies of copyrighted material are flowing through your network, the DMCA said that was okay in 4 situations. So transitory communication. If you're just the middleman in some data that's being shipped from here to there, you can't be sued for copyright infringement because you copied it from here and shipped it out of there. You just briefly had a copy, that's okay. System caching, sort of the same idea. Information stored at the direction of users. So what is that? Yeah.
Like if a user uploads a copyrighted video or something.
Right. So YouTube, this would apply to YouTube, that someone uploads and stores on YouTube a video. So I do that after every lecture. And when I do that, I'm implicitly claiming that I'm not committing a copyright violation, and I'm not, because it's my video. But I could also upload something that is copyrighted. So YouTube can't be sued under the DMCA for stuff their users are storing on YouTube, subject to something we're about to talk about. So YouTube has to behave in a certain way, and if they do, they're immune from lawsuits. Yeah.
Now, what if the user was not just a user, he was actual business, and he was actually loading stuff on YouTube to leverage his business, or his or her business?
Well, this just talks about copyright. So if some company is uploading copyrighted material, it would be covered. So to participate in these in these safe harbors, the ISPs like YouTube must participate in the notice and takedown. So have you ever had a link to something on YouTube and gone to watch it, and instead you find something that says this has been taken down because of copyright concerns? Okay, so that comes because of the Digital Millennium Copyright Act. So here's what a place like YouTube has to do. So they have to designate an agent who deals with this sort of thing. If someone uploads a tape of Saturday Night Live, NBC notices it. What NBC can do is notify this agent at YouTube, we hold the copyright on that tape that was uploaded. Please take it down. YouTube must expeditiously, so within a few days, they must take the material down and notify whoever put it up what has happened. Now, if the other party wants to argue about it, they can make a counter notification. Say, no, I hold the copyright on that. It's okay. In that case, the ISP, after a few days, has to put it back up and put the two parties into contact. So the law is designed so that the two people that claim they have the right to the copy can be put into contact, and then they can sue each other. So in order for YouTube to avoid being sued, they have to provide this mechanism. They have to support this mechanism. Take things down when they're asked to. So they don't have to judge the copyright. They take things down when they're asked to. They put things back up when they're asked to. But they also put the two parties in communication so that they can settle their differences. There was also in the DMCA a controversial provision that made it illegal to create or distribute or sell tools designed to circumvent copy protection. And there are a couple of examples. This first one amuses me. So the Digital Music Initiative challenged researchers to break their security, their copy protection. And so a research group at Princeton did it. They rose to the challenge. They figured out how to break it, and they submitted a paper to a conference, and it was accepted. And they were sued under the DMCA for creating anti-circumvention code, even though they'd been challenged to by the company that ended up suing them. It turned out that the paper was never presented and the case became moot. But just one example of what the DMCA allows. There was a programmer in Russia that figured out how to break Adobe's ebook security. And he was actually arrested stepping off the plane in, I think it was in San Francisco, somewhere in California, and eventually acquitted. You've probably heard of the Free Software Foundation. I mentioned them because that has to do with copyright. So they're a nonprofit, and they believe fanatically, many of them, in the idea of eliminating restrictions on copying and redistributing, understanding, and modifying software. So they don't believe that that they believe that programs should be free. And when they say free, they don't mean that you can't charge money for a program. They mean that when you obtain a program, you should be free to do what you want to with it. You should be able to modify it. You should be able to change it, add to it, and use it, or make your own thing out of it. And that's to software companies, that's a very radical idea, because even though the word free doesn't mean no charge, if you follow their philosophy to the end, then the fact that I have possession of Windows 10 on my laptop would mean that I'd be able to basically distribute to whoever I wanted to. So the way they, yeah.
Because different companies have different ways of serializing their programs, and so
Mm-hmm.
they'd have to give that to the user, and that could be distributed, and then anyone could get access to the software.
Well, that's what would, if software were free, meaning no restrictions on it, you just wouldn't have those things. You wouldn't have any need for it. So the way they do it is they copyright their code. So when something is produced by the Free Software Foundation, they copyright it, But what their copyright says is that you can do anything you want to with this code except embed it in a system, that has a more restrictive copyright on it. So basically, if you're a company, if you're an individual, you can take free software foundation code and do whatever you want to with it, as long as you leave the copyright alone. But if you're a company and you take their code and try to put a piece of it into your system and then put a restrictive copyright on the entire system and sell it, you're in violation of the Free Software Foundation's copyright, and they could sue you for copyright infringement. So their idea is, if you produce lots of really useful code that contains this, it's often called a copy left restriction, then it sort of infects any code it gets put into, in fact being a good thing in their point of view, so that it would tend to remove copyright restrictions off of all code if it propagated far enough. Okay, so that brings us to patents. So a patent is the right to exclude others from making, using, offering for sale, or selling an invention for 20 years. So copyrights cover expression. So programs can be copyrighted. In fact, any program you wrote, like I said, you automatically hold the copyright on it. To obtain a patent, it's different. You have to apply for a patent. And to do that, to apply for a patent, you have to disclose the invention. You have to produce a patent application that describes the invention in detail, how it works, what you're claiming is unique about it. And then there's an office, the USTPO looks at it and either grants the patent or doesn't. So it's a very different thing. Getting a patent can be expensive because you just got you need a lawyer to do it, to deal with the patent office. So you can patent an invention that is not obvious to someone skilled in the art. That's the sort of legal definition. So you have to argue that, the usual argument would be, well, it's not obvious because no one ever thought of it before. And anything you patent has to have a useful purpose and it has to work. So you can't patent gears. You can patent uses of gears. It has to, a gear by itself does nothing. But so you can patent ways in which gears can be used. And you can't patent time machine unless you actually have created a time machine. So it has to be something that works. Now, patents have been around since, forever, hundreds of years. But software patents only started appearing in the 1970s. The very first spreadsheet was about 1980. That was called VisiCalc. No one had ever seen a computer spreadsheet before. And the creator's lawyer told him he could not patent the idea, of spreadsheet, even though no one had thought of it before. And so he didn't patent it, and lots of other companies then made a lot of money on it, and he didn't. But he got bad advice from the lawyer because right around that time, software started being patented left and right. So when you patent an idea, when you patent software, you're not patenting the program, you're patenting sort of the idea behind the program, the novel idea behind the program. So in the case of spreadsheet, it would be the idea of a computer program that, with cells and dependencies and so on that you're familiar with. So to obtain a patent, you have to file a patent application with the patent office. So that's where lawyers get involved. And then they hire examiners. So your patent application is given to a patent examiner who looks for prior art. And so what that means is the first thing the patent officer is going to do is search through existing patents and see if this idea has been patented before. Now, in the early days of software patents, it was a big problem because there was no prior art in the form of patents. Software had been around for 30, 40 years. No one ever patented the do loop, the for loop. No one patented the conditional. Probably could have. The method, whatever. Those ideas all could have been patented, but they weren't. And so it made it hard for patent examiners to figure out if something was really novel, because they couldn't just look back in the patent literatures. They had to know a lot about the field to see if this is an idea that's been kicking around for 20 years and someone's just now patenting it, or is it truly a novel thing? It can take a while. A new patent examiner might take 80 hours, so 2 weeks, to figure out if a patent should be granted, and a more experienced one less. It can take 18 months in all. I'm not sure where all those other hours go, but it can take 18 months. It's not adversarial, so the patent examiner isn't listening to two sides about whether something should be patented or not. It's become easier. There was reform done a few years ago that made it easier to challenge a patent after it's been granted, but it's still hard to overthrow a patent, to get rid of a patent. Before 2011, it was always the patent was given to the first person to invent something. Then it switched to make it consistent worldwide to the patent goes to the first inventor who files. So that seemed like a big deal at the time, but it doesn't seem to have made much difference in practice. So let me tell you a story. The senior projects are done at the end of each semester. We have demos of senior projects. So in 2012, I remember going to a senior project, and it was out in the courtyard there, right outside here. And it was in the courtyard because the group had taken like a smoker that you smoke meat in, so sort of a fancy barbecue grill, and they stuck a bunch of sensors in it and controls, and basically they could control the thing with Wi-Fi. So he could be on his smartphone and see the temperature inside and how long it had been cooking and whatever else was being sensed, and could change the settings on the phone from the phone as well. So it was like a Wi-Fi, maybe I don't know if it was Wi-Fi or Bluetooth, but anyway, it's a remote controlled smoker. And so that was 2012. So then I got email just a couple weeks ago from this student, asked if I remembered him and if I remembered his senior project. And he said he had been trying to partner with barbecue equipment manufacturers to use this idea. And what he found out was that a company in 2015 had patented the idea. Furthermore, the company that had patented the idea was one he had contacted right after he graduated to see if they would partner with him. So basically, he disclosed his idea to this company. They said, not interested. And he believes they just turned around and patented the idea. And so now he can't find any company that will work with him because of this patent. And so now he's considering legal action to try to get the patent invalidated. And so he was contacting me and like Jim de Saint Germain to see what documentation we might have that would show that he had the idea in 2012. So if you have a great idea, be careful. Right. Get them to sign a non-disclosure agreement or something. But yeah, be careful with your ideas. Yeah.
They have an episode of Silicon Valley where they go over that.
Yeah.
Where they're trying to get like their method out, and then they just keep taking notes as they're like, well, how do you do this? Oh, I don't believe him, and they're showing it. And
Right.
They're just stealing it.
Yeah. No, I had a guy come to my office once, and he said he had this great idea, and he needed help creating it, implementing it. He wasn't a programmer. And so he ended up paying me $500 to sign a non-disclosure agreement so he could explain his problem to me and I could help him figure out what to do about it. And so, I took his money and signed his agreement. And the problem, what he had was, you've probably seen these stencils you can make. You can buy stencils for carving Halloween pumpkins, where you get a few crappy little tools, a little saw, and you make these fancy things that really look pretty impressive from a distance. You can carve them. And so his idea was to have a program where you would take a picture, this was back probably before there were smartphones, but there were digital cameras. So you take a digital picture, and the software creates a stencil for you. And so he called his idea "Me on a Pumpkin." And I thought that was a neat idea. And so I put him in touch with a programmer I knew, who was Peter Jensen, who was a graduate student at the time. And Peter coded it up for him, and he marketed it for a while. I don't think it made him rich, but I remember seeing it on the store shelves. Peter took that software and went to a pumpkin carving contest over at the Student Union. And he had a picture of Urban Meyer, who was the coach of the football team at the time. And Peter won first place in that pumpkin carving contest for using stencil generated by that software. So, but I made $500 for doing almost nothing. So I think I made out best. So there are problems with the patent process. There are not enough examiners, so it takes a long time. They're not paid very much, and so they're not necessarily the most technically competent people you could have judging whether a patent is valid, whether it's really a novel idea, whether it's adequately explained. I already mentioned the problem of insufficient prior art because patents weren't granted for a long period of time. So there's sort of a blank in the history. And then there are these patent trolls. So patent trolls are companies, they're in business only to acquire and enforce patents. So they're not producing anything useful. So Microsoft holds a lot of patents, and Amazon holds a lot of patents. And if Microsoft wants to sue Amazon for violating a patent, then Amazon can sue Microsoft back for violating a patent. So there's sort of this mutually assured destruction, and they don't bother each other. But the trolls don't do anything useful. They just hold patents, and they try to extort companies to pay up or be sued out of business. And they don't bother suing the big companies. They sue the little guys, because big companies can afford lawyers.
Sometimes
Yeah.
they sue Apple and win. Yeah, pretty sure they
Yeah.
sued Apple to like serialized, like anything that's serialized and listed,
Yeah,
and
yeah, I can believe it.
several $1 million.
Yeah. So let me show you what a patent looks like. So we talk about patents, but let me show you what patent application looks like. So I'm going to leave this presentation and look at, where is it? Now I picked this patent. I'm going to show you two patents. I picked this one just because it's short and kind of funny. And let me make this bigger. It's not expanding here. Let me try again.
Are they patenting mechanics?
Okay, so the patent this was granted in 2005, Sanity System for Video Game. So it was invented, it lists the inventors. So these three people here were the inventors, but they were employees of Nintendo. So Nintendo actually holds the patent. It's filed in 2000, eventually granted. I'm not sure what all the dates are there, but so this is what a patent looks like. It has that stuff at the top. It has lots of diagrams in it, and usually they pick an interesting diagram from the patent application and put it on the front page for some reason. So I guess make the patent more fun to look at. So what was patented was the idea of you're playing a video game and the character goes insane or begins to lose sanity, and that affects the gameplay in some way. So there's some feedback. Something causes sanity to be lost, which in turn causes your character to start behaving erratically. And so this picture shows, I guess that's the character losing sanity when it sees that, and this is some sort of measure of the sanity of the character. So that idea, which I don't know, I'm not much of a video game person, but it sounds like it ought to be a common idea. I don't know.
Yeah.
So, but anyway, that idea was patented in 2005. So when you read a patent, it starts with an abstract that sort of explains the idea. So it says, a video game and game system incorporating a game character's sanity level that is affected by occurrences in the game, such as encountering a game creature or gruesome situation. And it goes on to explain the key idea. Then, when you read through the patent, you'll see, like here's a diagram, a flow chart. It says you start, you have a sanity level, the game progresses according to sanity level, a gruesome event happens, it affects the sanity level, you modify the sanity level, and you continue. So that's sort of that's a diagram that explains what's going on. There's that picture again. This is a picture. So that's Mario right there, and so they all, there's the computer, and it's all labeled. Here's another block diagram. We're finally get to the text at some point. That just shows a computer system with interfaces and CD-ROMs and video adapters. Because you get into this text, it gives detail about how computers can be hooked up, and just how it just tries to explain every detail about the context of this thing. So you read through this. I don't think I've ever read, well, I have, but I don't often read all the way through every one of those things. And then the important thing is at the end. So at the end, you can see right here it says what is claimed is. So at the end of the patent are the claims. And so if you want to judge whether something you are doing violates a patent, you have to judge whether it violates a claim. And there'll be a whole bunch of claims. And the rest of the patent just exists to define the terms used in the claims. So this says that what is claimed, what we're patenting, is a method of operating a video game, the method comprising setting a sanity level, modifying the level according to occurrences in the game, controlling gameplay according to the sanity level of the game character. That is claim 1. Claim 2 is just like claim 1, except in step B, there's a gruesome situation. Reducing the sanity level upon encountering a game creature or a gruesome situation. So basically, they're thinking of all kinds of scenarios in which this idea might occur, and they're trying to enumerate all the ways that this idea might be used. And so if they want to sue you for patent infringement, they have to say, you violated claim 17, or you violated claim 2. So to really understand the patent, you got to read the claims. See what's being asked. I once worked as a consultant for a law firm in Denver that represented one large software company that was contemplating suing another large software company for patent infringement. And my job was to read these patents and sort of advise them on whether company B, whether their software seemed to be violating these patents. And it was very interesting dealing with these lawyers. I spent hours on the phone talking about individual claims and trying to understand whether something was being violated. So it's a very expensive lawsuit when you get those lawyers involved. So that's that. Here's a very famous patent. It's the Amazon one-click patent. Oh, okay? So you go on Amazon and you want to buy something, you can buy it now, right? You can put it in your shopping cart, and you can shop, and then you can go fill out a form and order it. But if you've got things set up in advance, you can just click one button and it's ordered and paid for and shipped. So they patented the idea about that idea of providing a one-click option, about 20 years ago. So I guess the patent's about to expire. And this patent is famous because it was actually partially invalidated. So some of the claims in the original patent turned out to not have been original ideas. They had existed before. And so parts of the patent were invalidated, but not all of it. So you can see that one of the inventors is Jeff Bezos. And Amazon holds the patent. And if we just, here the picture on the front is not very interesting. But actually, maybe it is. If I read it to you, it says, retrieve client ID, set client customer mapping, set single action ordering for client ID/customer, return confirming web page. So that's...
You're right.
Yeah. But I'm trying to find the claims back here. Those are the citations. So a patent's a legal document. Wow. So it's well cited. Wow. I'm not sure what that is. Oh, that's something that...
Updated one?
Yeah, this is the updated one. Okay.
After the lawsuit, do they update it? Like after certain claims are invalid?
Yeah, they issued a revised patent.
Right.
So you can see a method of placing an order for an item comprising displaying information in response to only a single action, sending a request to order the item along with an identifier of a purchaser, receiving a request, retrieving information, generating an order, whereby the item is ordered without using a shopping order model. Claim 2 is just like Claim 1, except I'm not really sure what that means. Displaying information includes displaying information indicating a single action. Claim 1, where the single action is clicking a button. Claim 1, where the single action is speaking a sound. Now, I don't know you can do that on Amazon, but they patented the idea. So that's what a patent looks like. And I've never applied for a patent, but you would have to spend a lot of time with a lawyer and a lot of time writing to describe what you're after. Yeah?
If you were interested in trying to find out if a certain patent doesn't already exist,
Mhm.
Is there like a website for like software patents that you can
I don't know about software patent specifically, but Google, there's Google patent, which, so what intellectual property lawyers will do if you apply for a patent is do their own patent research. And I'm not sure what tools they use, but they're free ones you can use to see what's been patented. Yeah?
What about patent pending?
Patent pending means you've applied for a patent, but it takes 18 months, 2 years for it to be decided. So it means that's in the process of being judged, but it hasn't been granted yet.
So how protected is your product? Because a lot of people will release something while it's still patent pending.
Mm-hmm.
Is it still protected because you're in the process?
I don't know if it's protected then, but maybe the protection is retroactive. I'm not sure.
I think you could sue people if they start making products during that time if your patent doesn't go through.
Right.
Right.
So it's sort of retroactive to the time
So
you
it's
apply.
risky for the other company
Right.
to use your product.
Yeah. All right, so I'll just finish up a few things on patents and we'll be done. So those are examples of patents. So that challenge I mentioned happened, and the patent was around for about 5-6 years, and then it was challenged, and that wasn't resolved till 2010. Okay, here's some patent cases. The people that make BlackBerry, they were sued by a patent troll. It was some patent related to email. And the story is that the BlackBerry didn't take them seriously, and as a result lost $612 million to them in 2006. So Merck Exchange, what is that? Anyone know what that is? So they held a patent related to Buy It Now, I guess different from Amazon's patent. And I guess Merck Exchange was another troll. What they saw was an injunction preventing eBay from using Buy It Now until the main lawsuit was decided. And the Supreme Court ruled that an injunction was not required, that eBay could continue using Buy It Now while the case proceeded. It sort of hurt trolls, which is a good thing, and eBay ended up paying them, though, to buy the patents. And this one is more recent, Apple versus Samsung. They sued each other. So Apple said Samsung violated patents related to the design of an iPhone and to how you use it. And Samsung said Apple violated some wireless patents. And the jury sided with Apple and awarded them $1 billion. So big bucks in these things. I don't know how much the lawyers had to pay. Got paid. I mentioned that this is a website that our retired professor Lee Holler maintains. It talks about intellectual property. He used to teach an intellectual property class before he retired. That was pretty popular. So anyway, that's the scoop on intellectual property. We'll end here, and I'll look for you on Thursday.